while the CERB program is helping many weather the financial storm of COVID, it has also been a source of confusion for many Canadians. Here to clarify and answer some of your questions is employment lawyer Lior Samfiru. Thank you so much, as always, for joining us, Lior. I mean, so many questions have come in. I'm sure you've heard many of them. Let's begin with one of the important ones that we've seen. And we've seen a number of workers walk off the job over worries about safety. What rights do these individuals have if they do not feel safe at work?
That is an extremely important question. There's a lot of misconceptions there. And a lot of people believe that if they feel unsafe subjectively, they can be off work, and then the government will pitch in and help them with the CERB. Well, that is actually not the case. If you make the decision not to go to work, even if you have good reasons, which many people do, not only do you not qualify for the CERB, that's a benefit that's available to those where the employer decided they can't work, you actually may be considered to have resigned. So that's not a good thing. Instead, someone that does feel unsafe, if they can show that the workplace is dangerous, they may be able to engage in a formal work refusal, which would require their employer to bring in the Ministry of Labor, who will then determine whether the work should continue or not. But no one should simply decide on their own that they're not working. Talk to your employer if you have to engage in a formal work refusal, and do it that way.
Now, we're also hearing stories where some people, for example, in a lot of jobs, lower paying jobs, for example, they have to go to work. They have to take the risk every single day, whereas a lot of people are being able to, and they're critical of this, are being able to take advantage of the CERB, but they're saying, look, they make more than I do, and I'm going to work every day.
Yeah, Anthony, I've heard that many times from employers and employees. And when a lot of employees are saying, well, if the government's going to pay us $2,000 to stay at home, why would we go to work? Number one, we may be making as much or maybe less at work, and why would we put ourselves at risk? So this is, again, important to clarify that if an employee makes the decision not to go to work when that work is available to them, that employee may be considered to have resigned and then get disqualified from the CERB. There's a lot of misconceptions about it, but it's not designed, the CERB is, for those that can work. So the individuals that may make that decision, if their employer is inclined to issue a record of employment saying you've resigned, that employee may have to repay back the CERB. There could be fines, there could be penalties. The government has said, we want people to be working, and that's what the CERB is designed to do, to not be there if you are able to work, and to be there for you if the work is not available.
Now, the wage subsidy program will help a lot of companies, a lot of employees as well. A lot of employees obviously have been laid off, temporarily in some cases, in other ways it hasn't been clearly defined. When does a temporary layoff become permanent?
So the biggest misconception with respect to a temporary layoff is the idea that it's even allowed. In most situations, a temporary layoff is actually illegal. Even in the COVID situation, an employer does not have an inherent right to lay off someone temporarily. Now, if the employer does it anyway, that employee now has a choice. They can choose to treat that temporary layoff as a termination and pursue their severance, or they can accept it and wait and see if they're called back to work. Now, if they are choosing to accept and wait it out, for most employees after 3 months or 13 weeks, that temporary layoff becomes a termination automatically. It does vary by province, but usually it's 3 months. So you can either treat that as a termination now or wait it out. Either way, keeping in mind that if you're not back at work, severance does have to be paid in full.
So here's a question that I've heard and I've seen come up in a number of cases. People have been taking pay cuts in a way to sort of help their company and obviously to help keep their job in the long term. But how exactly does that work? Do you have to have it in writing, or because you don't even know if this is going to become a permanent situation, do you?
It is very important when it comes to changes to terms of employment, to, number one, to get it in writing, and number two, to obtain confirmation that it is only while we're dealing with the virus. And also, by accepting this pay cut, you want to be on record saying that, just so you know, employer, I'm not accepting it again in the future. The concern with accepting a pay cut now, even though we're dealing with this virus, is that by opening that door and allowing that pay cut to happen, you may be giving your employer the right to do it again in the future, even for other reasons. So an employee really wants to be on record and in writing, email, or anything else, saying that I will accept this now, but I'm not agreeing to other pay cuts in the future that is important to do in order to ensure and defend your employment rights.
Incredibly important advice. Lior Samfiru, always a pleasure to talk to you and get some answers to some very important questions. Thank you again.